He is the leader of Poschim Bongo Chhatra Samaj,
All right.
who has organized a protest rally on 27th, a peaceful protest rally. The huge police harassment was there. Ultimately, they were apprehended, even if when there is no 144 area.
আপনাদেরকে বলে রাখি, কলকাতা হাইকোর্টে বিচারপতি অমৃতা সিনহার বেঞ্চে রাজ্যের অ্যাডভোকেট জেনারেল কিশোর দত্তের সঙ্গে পুলিশের হাতে গ্রেপ্তার হওয়া ছাত্রনেতা সায়ন লাহাড়ির মামলা করা ভিত্তিতে শুনানিতে যে তর্ক বিতর্ক চলল তা কিন্তু আশ্চর্য। শুনানিতে তার গ্রেপ্তার নিয়ে বেশ কিছু প্রশ্ন উঠেছিল। শুনানি শেষে রায়দান স্থগিত রেখেছিল বিচারপতি অমৃতা সিংহ। পরে তিনি তার নির্দেশে সায়নকে মুক্তি দেওয়ার কথা বলেন। পাশাপাশি বিচারপতি সিংহ নির্দেশে জানান, আদালতের অনুমতি ছাড়া আগামী দিনে কোনো কড়া পদক্ষেপ করা যাবে না সায়নের বিরুদ্ধে। এছাড়া বিচারপতি আরও বলেন, শুধু এই মামলাই নয়, অন্য কোনো মামলাতেও যদি তার বিরুদ্ধে কোনো এফআইআর থাকে সেক্ষেত্রেও কিন্তু কোনো কড়া পদক্ষেপ করতে পারবে না পুলিশ। শুক্রবার ছাত্র সমাজের নেতা সায়নের গ্রেপ্তার নিয়েও বেশ কিছু প্রশ্ন তুলেছিলেন হাইকোর্ট। আরজিকর হাসপাতালের প্রাক্তন অধ্যক্ষ সন্দীপ ঘোষকে কেন গ্রেপ্তার করা হয়নি তা নিয়েও কিন্তু প্রশ্ন তোলেন বিচারপতি অমৃতা সিংহ। বিচারপতি বলেন, ওই ঘটনার জন্য প্রাক্তন অধ্যক্ষ দায় এড়াতে পারে না। তাছাড়া তাকে কি হেফাজতে নিয়ে পুলিশ জিজ্ঞাসাবাদ করেছে। কেন সায়নকে গ্রেপ্তার করা হয়েছে তা নিয়ে বিচারপতি প্রশ্ন তুলেন। রাজ্যের বক্তব্য, ওই ছাত্রনেতা নবান্ন অভিযান কর্মসূচির ডাক দেন, আর ওই কর্মসূচিতেই পুলিশের অনুমতি ছিল না, তারপরেও মিছিলে জমায়েত করা হয়েছে। এরপর রাজ্যের আইনজীবী নবান্ন অভিযানের কয়েকটি ছবি বিচারপতি সিংহের সামনে তুলে ধরেন। এরপর হাইকোর্টের প্রশ্ন, সায়ন কেন রাজনৈতিক দলের নেতা নাকি? রাজ্য জানায় তিনি তো ছাত্র নেতা। যা শুনে বিচারপতি অমৃতা সিংহ প্রশ্ন করেন, ওই ছাত্র নেতাকে কীভাবে এত প্রভাবশালী বলা হচ্ছে? তিনি কি এতই জনপ্রিয় যে ডাক দিলেন আর হাজার হাজার লোক জড়ো হয়ে গেল? তার কি কোনো অতীত রয়েছে বা রাজনীতিতে রয়েছেন? বিচারপতি বলেন, আরজিকরের ঘটনায় মানুষ মর্মাহত, ওই ছাত্রনেতা প্রভাবশালী নন। ওই ঘটনা ঘটার আগেই তার বিরুদ্ধে কোনো অভিযোগও নেই। রাজ্যের যুক্তি, নবান্ন অভিযান নিয়ে সায়ন প্ররোচনামূলক বক্তব্য রেখেছিলেন। এরপর পাল্টা বিচারপতি মন্তব্য করেন, অনেক রাজনৈতিক নেতাও তো প্ররোচনামূলক ভাষণ দেন, তাদের বিরুদ্ধে কি পদক্ষেপ করা হয়েছে? এরপর উভয় পক্ষের বক্তব্য শুনে আদালত এই মামলার রায়দান কিন্তু সাময়িকভাবে স্থগিত রেখেছে।
I lead a rally, and may I say this, there are specific statements made by him which were extremely provocative. He made a press conference the day before and said, I will not take permission. He said, I'm going to take out 2 processions. He took out 5. So he was the one who was misleading everybody. He was the one who was leading it. And my lord, your lord should kindly consider one thing. Can I today call for a rally, meeting, procession, and say that I will not be responsible for anything that will happen in that rally? He was specifically intimated that please let us know where do you want to do, how many people were, letters were written to him. This is, his name is number 3 over here. We were sought for details. He said his basic statement in the press conference, I will not give any details. After that, can he say that he will not take any responsibility? On the factual score, these are things which the learned advocate general could not have handed over to your lordship. Milord,
Yes.
if the Supreme Court order was placed at length, my lord will
No, I'll place that. Mr. Banerjee, I'll place those.
let the advocate.
I'll place those. Yes. Now, my lord, since Mr. Muzumdar had started from the previous round of litigation, your lordship has been rightly pleased to observe that the previous round may not be essential for deciding the present prayer of the petitioner. But, my lord, I need to, my lord, take your lordship through, my lord, a very few sentences, my lord, of the Supreme Court and the High Court orders. Now, the first one is, my lord, if your lordship may kindly have a look to, my lord, page number 91. Where the order of the Supreme Court starts from page 89. Please have a look to, my lord, paragraph number 5. Nothing to do with, my lord, the previous incident, but my lord, only some observations of the Supreme Court. The paragraph 5, my lord, of the order of the Supreme Court dated 20th of August. In the aftermath of the brutal incident and the demonstrations which followed, the state government was expected to ensure the deployment of the state machinery to prevent a breach of law and order. It was all the more necessary to do so since investigation of the crime which took place in the precincts of the hospital was underway. We are unable to comprehend how the state was not prepared to deal with the incident of vandalization of the premises of the hospital. Pausing here for a moment, my lord. We are now dealing with a case subsequent to all these, that is on 27th of August, my lord, where, my lord, the state was, my lord, prepared to, take note and, my lord, prevent any kind of vandalism. Whatever was the preparation of the state, everybody knows, my lord, I need not dilate on that. Whether it was peaceful or not, everybody knows or not. Who instigated, everybody knows, my lord. I do not want to dilate on that, my lord. That may not be relevant, my lord, for the purpose of this case. Therefore, my lord, my first submission is, my lord, here, my lord, the state was, my lord, ready to, my lord, deal with the, my lord, vandalism. Now, what did the state do, my lord? My lord, again, my lord, with half-baked, my lord, instructions and, my lord, making this submission. My lord, there had been, my lord, at least 25 to 30 preventive arrests, my lord, on the previous night, where, my lord, people were ready, my lord, to, my lord, do certain acts of crime with, my lord, various weapons, etc. They were, my lord, preventively detained. Second is, my lord, in respect of the incident, wherever they have happened, whoever is responsible for that, my lord, there has been more than 150 arrests. But all arrests, my lord, have been made, my lord, after identifying the people, my lord, from the video recordings which were with the police, which are in the social media, which are with the media people. Therefore, my lord, when the petitioner has been arrested, my lord, the petitioner has also been identified by the police authorities, my lord, based on certain, my lord, what should I say, the materials. But this is my second submission, but these will all be placed on record. Now, my lord, kindly take, my lord, the next order of the Supreme Court, that is at page 105, which Mr. Muzumdar has also relied upon. In fact, this is the third order, because on 22nd we have two orders. The other order has not been annexed, so, my lord, I don't go through that. Please take, my lord, paragraph number 9, my lord, at page 112. Mr. Sibal, senior counsel appearing for the state of West Bengal and the Kolkata police, submits that while this court has permitted peaceful protest, the order should not be misconstrued to mean the authorities. But this is very important. Authorities are precluded from exercising their regulatory powers in accordance with law. Now, my lord, regulatory powers can be in two manners. One is, my lord, the regulatory powers, my lord, by way of restrictions under Article 19(2) of the Constitution, which includes, amongst other, my lord, 144 orders, my lord, now 163. My lord, the other regulatory, my lord, powers, my lord, are exercised, my lord, under the Police Act. That is why, my lord, your lordship finds, my lord, whenever somebody wants to organize a demonstration, procession, etc., my lord, they apply before the police. If the police grants permission, they organize it. If the police does not grant permission, sometimes, my lord, they come before the court. Your lordships pass appropriate orders. Now, my lord, these are, my lord, the regulatory powers of the police, that anybody and everybody, my lord, having, my lord, right under Article 19 cannot, without regulation by the police, conduct these kinds of processions, demonstrations, etc. Therefore, Milord, the Supreme Court was very categoric by saying that the state is not precluded from exercising their regulatory powers in accordance with law. Now, pausing here for a moment, Milord, may I only briefly state once more what Mr. Banerjee has said. Now, Milord, this petitioner's son, Milord, who had allegedly called this Chhatro Samaj demonstration, was asked by the police, you please apply for permission. What are the routes? What are the numbers? So that either we grant permission or we don't grant permission. Now, Milord, this regulatory power of the police was prevented by the writ petitioner's son by flatly saying that no, nothing doing, we are not going to apply. Therefore, Milord, the first conduct of the writ petitioner's son in, Milord, denying or refusing to apply for a permission which is otherwise required under the Police Act of 1861, Milord, is contrary to, Milord, what the Supreme Court has said, Milord, in paragraph 9, first sentence of the order of 22nd of August 2024. Therefore, Milord, my second submission is that the writ petitioner's son has, Milord, not only acted contrary to law, he has also, Milord, prevented the state, by the order of the Supreme Court, to apply for permission for holding this demonstration. Therefore, Milord, the action of the writ petitioner's son prima facie is contrary to law, as well as, Milord, contrary to the order of the Supreme Court in its letter and spirit. So that is why, Milord, the first petition, the previous petition that your Lordship has been pleased to deal with in the supplementary list today, they had applied before the police. Police did not permit, your Lordship had passed appropriate orders. Therefore, Milord, application before the police is a precondition to hold, Milord, any procession, demonstration on public premises, on public roads, etc. So this has been defied by the writ petitioner in spite of the police, Milord, having Milord approached him. Milord, now, Milord, may I go back to, Milord, page 112, the next part of paragraph 9 of the Supreme Court's order.
May I also just inform you one thing, that a number of permissions have been taken, a lot of
Yes, I know that. I'll make those
petitions have been filed in this court.
Wherever permission has not been taken, what action the police has taken? Now, please consider, Milord, paragraph number 9, where the Supreme Court has said this court has permitted peaceful protests.
I do not, as of now, I don't find him to be a very influential person who can garner so many people by only one call.
Milord, that is his admitted case.
Well,
it is his admitted case.
Let him admit. You have to find out whether...
No, we have our evidence, Milord. Milord, my submission is that in the backdrop of paragraph 10, he cannot say he is innocent. In the backdrop of paragraph 10, he cannot say that he is not responsible. And apart from that, Milord, my evidence is why I have picked him up, Milord, I'll place before the court. But not at the threshold that he should be let off. In the backdrop of paragraph 10, take it up on Tuesday or Wednesday. In one day, Milord, I'll file my affidavit in opposition.
Is his custodial interrogation so very important?
Very important, Milord.
What powers does he have to tamper evidence? Will he flee away, not give any witness when called for? These are the things which have been laid down by the Supreme Court at the time of
Milord, in an appropriate, yes. Well, in an appropriate case, where, Milord, an accused comes and denies that I am in no way involved, in those cases, Milord, these parameters apply.
And one of the documents which have just been handed over by Mr. Banerjee here is a letter written by one Probir Das, who happens to be one of the persons in the same letter to which the petitioner was addressed calling
Yes,
for
sir.
the number of people to give details and seek for permission, right? Now,
Yes,
this
yes.
person, Probir Das, he mentions that with profound respect, please forward this to him also.
May I just see that letter once? Which one is that?
26th of August 24, just now you handed over.
I'll just see it once.
Yes,
Reply to 24th letter.
Yes,
Reply
yes,
to 24th
absolutely.
letter.
Right, right. It was forwarded. Possibly it was forwarded just now to you.
Because
It
No, I
has
have
al-
not received it. Is it an email?
it was forwarded.
Yes, yes, it's an email. Yes, yes, yes.
Yes, I forwarded it.
Yes. It's an email communication.
Right, right, right.
Right. With profound respect, leave
Yes,
the first
yes, yes.
paragraph. The same would be a march towards Nobanno, the state secretariat, the student society, as well as the general public at large, irrespective of their caste, creed, religion, political identity, would be a part of this rally. The rally would be a means of a democratic and a non-violent protest. We have come to know from reliable sources that miscreants engaged by the ruling dispensation in the state would try and use tactics to defame the students and the
Yes.
general public at large by using violent and other malicious means.
Yes.
They would also take resort to various tactics to attack the protesters and the police personnel and defame the society. Steps may be taken to avoid such undesirable situation.
Right.
Not
How many
direct from Probir, but from one of the
Right.
addressees to the notice. They
Right, right, right.
fall on the same plane. I
Yes,
do
yes.
not know whether you have arrested Probir or not.
Yes, he's arrested.
He is also arrested. Very well. The
And how many students were found in that agitation? Everybody knows. Finally,
it has crossed the boundaries, Mr. Dotto. Everybody, not only students, children, women, men, everybody.
Millard, I would be Millard. I would Millard try not to make any submission on those, because Millard, that would be bordering on the merits of another case.
Yes. So let us not go into those.
Yes, yes.
We
Therefore,
will.
Millard, I very respectfully submit, Millard, this is an admitted case.
Yes.
He does not anywhere say that he is nowhere associated. He
Right.
points out fingers at the police. That's his case only.
But that is democracy also, isn't it?
No, democracy, Millard, the expression, Millard, democracy, Millard, I think, Millard, was best, Millard, explained by our late president, Mr. Pranab Mukherjee, who said India is a democratic country because all kinds of persons, Caucasians, Dravidians, Mughals, the descendants of everybody can live together. I think, Millard, that is the best definition of democracy, Millard, that I have ever, Millard, come across. Now, Millard, here, Millard, again, Millard, democratic rights or fundamental rights under Article 19 is not unregulated and unrestricted.
But do you not think that the manner in which you have treated this person is a pressure tactics not to continue with the protests?
Millard,
The persons who were actually responsible for the act for which they are protesting, they are yet to be identified, steps taken against them. Now you try to nab these people who are protesting.
No. Millard, kindly, Millard, do not, Millard, look at it from that point of view. But hundreds and thousands and lakhs are protesting.
Yes. And you
But in
pick up
those-
somebody who's trying
Then no, Millard, in that case, Millard, people will go away. Well, it is one thing to, Millard, peacefully protest.
Yes.
It is one thing to, Millard, address your lordship. It is another thing to use unparliamentary language while addressing your lordship. Please consider the difference.
Yes.
Therefore, my lord, if 10 people agitate and 2 people of them, my lord, act in some other manner, but I have a right to, my lord, dissociate the 2 persons from the other 10 people. That regulatory right the police must have, otherwise, my lord, police will lose all its powers.
If the protest or the rally was initially peaceful and then somebody else hijacked it and made it unruly, why will you get hold of the person who organized the peaceful rally?
No. He's not only the organizer. He was a person who led it from Strand Road. It went on till Babughat. At Babughat, it became violent in his presence.
And Babughat is Babughat within the 144 zone? It isn't. Then
violence.
You find him to be very unruly in Babughat. You arrest him.
No, damage to. It's not unruly only, my lord. It's not only unruly, my lord. At Babughat, my lord, several properties were damaged. Private properties.
Was he personally responsible for this damage? Did you find melting stones or anything?
Yes.
The photographs that have been produced.
But I do not know which photographs have been produced, my lord. The instruction that I have.
Do you find any of the photographs where this person?
Coming in, we are not.
So how do you know whether these photographs are related to this incident?
These are all as far as that incident, that place. All are of Strand Road.
I do not know. Then
you can put it on affidavit.
That will not. I will
put it on affidavit.
I will apprise the court by way of an affidavit. I am saying that give me 1 day time. Give me 1 day time.
Yes.
But he is not that innocent. This is an admitted case. Now, only thing which is troubling the court is his personal involvement.
Right.
But my lord, I have a twofold submission. As I said.
1 minute. And not only his personal involvement, he tries to make out a face of himself and somebody from behind is running the show. You don't get hold of the right person. You hold the person who is there in front.
Very well. My lord, may I, my lord, remind your lordship, my lord, of the various orders that your lordships pass. That when the state refuses a permission, somebody comes before the court, will your lordships provide those conditions that give the name of the organizer? What is the purpose? If there is any damage, he is made responsible. Therefore, my lord, assuming for argument's sake, for the time being, that he had not destroyed any property, assuming for argument's sake that he was having both of his hands in his pockets when everything has happened, then also, my lord, in view of paragraph 10, my lord, he cannot say that I have no responsibility. And in fact, he has never said so. Please come back to, my lord, paragraph 10 onwards, but I was emphasizing on that. But how can, my lord, these submissions be made in the court when there is no, my lord, averment to in the writ petition? But I am not, my lord, contesting a case where what has been said verbally is part of the pleading. I am not taking.
You have to see that the writ petition has not been filed by the person who is in custody. It is the mother
right,
who just comes
right.
So
therefore,
she may not have all information either.
No. I have not taken that point whether the mother could have moved this petition or not. I have not taken that point. The Shayan Lahiri could have himself also moved the writ petition by furnishing a wakalatnama from the
custody. Yes.
Now kindly take me at paragraph 10 once more. Then kindly take me at paragraph 11 once more. Then paragraph 12 comes suddenly that several FIR has been registered within a short period of time. The state are entangling the petitioner's son in one after the other cases to harass him. The petitioner's son is aware of 3 other FIRs in which he has been arraigned as an accused, and he expresses his great aspersion that he will be shown arrested in such FIRs. One such FIR being etc. Where does he say that he was in nowhere involved? My learned friend says that there is no vicarious liability. I am not on vicarious liability, I am on the direct liability. Now the question is, he does not adhere to the law. He does not adhere to the Supreme Court's order. He does not take any license. Now he is only confined to saying that, where are the evidence against me? What is the direct evidence against me? You have picked me up out of nothing. But he cannot say so. He will give a call and then say that, oh, I don't have so much might to gather so many people. He may not have the might, but if he has called it, he has to take the responsibility.
Very well. It is enough. Please
Yes,
don't take any more.
More than enough.
Don't take any more strain. Take care of